Whoever owns the soil, it is theirs all the ways to the sky and all the ways to the depths. But there's a question arising, right? How could a landowner owns the sky and the depths? Well, that's what our discussion for today is all about. A good day to Dr. Kanagaraj. This is Vimallen here, and I'm going to present myself on the Latin maxim expression as stated in the presentation. So let's get started. As we can see in the introduction, to sum up what the authors are trying to say is the maxim indicates that the landowner has the entitlement to enjoy the right to the extent of horizontal to the vertical uh, of the sky. And this is further illustrated in Law of Property Act 1925, where land can be anything even if it is not on the surface, such as gas, structures beneath the soil, or bridges. This further illustrated in uh, corporal heritagements such as lands or buildings, or incorporeal heritagements such as easements, right of access to property. And I would like to further illustrate in the historical background of this maxim, where this maxim was introduced on 12th century and now in England, and now it has become a guidance for the English courts in order to decide on the right of ownership for a person. And this further been documented on the 15th century in the case of Bury and Pop 1507, as it also was adopted by Lord Cobb and William Blackstone in their writing the heading Terra. And further, if we go further on the 20th and 21st century, this maxim uh, is seen as the contemporary perspective, where it is used as a metaphorically because of tall buildings, aviation, and subterranean mining, as stated by McQuaid and Stanley in 1996. And as we can see in the case of Bastian and Skybees 1978, this maxim requires courts to limit the heaven at Coelum limb due to aviation concerns. And the hell at Inferno limb is finally established in the Barcoda and Star Energy 2010 case, which I will explain it much further in the next slide. So, in order to understand the Barcoda case, first we must understand that land has three elements: land of surface, subterranean, and airspace. So, this the facts of the case is Barcoda possess freehold property in survey, and Star Energy drilled three directional oil wells underneath Barcoda's property without authorization. Therefore, due to this lack of authorization, Barcoda filed a lawsuit for trespass, not for ownership of the oil. And the issues here are: does a property owner title reach to the underground layers far below the surface? Can deep drilling still be considered trespassing even without affecting the surface? Therefore, the court held the Star Energy responsible for trespassing, and the, the land ownership extend downward without limit within the scope of possible reasonable use, and the courts affirmed the maxim. And Barcoda even cites the case of Mercury Communication Limited versus London and India Docks Investment Limited for its statutory courts of acquiring rights. So, through this case, the Parliament has introduced Infrastructure Act 2015, Section 43, where this act created a new statutory rights of use for petroleum and geothermal energy below 300 meters, for which we can see from the Barcoda case. And further, this Barcoda judgment was analyzed by these two cases of ARC Aggregates Limited and Boston Properties Limited 2020, and the Falkland and GE Capital EMEA Finance Limited, where a High Court case was held by Judge Snowden, also used the analysis of the Supreme Court Barcoda case. So now we're going to delve into the third dimension, the right of use and enjoy. So firstly, ownership of subterranean, where they are groundwater and oil and gas. First, groundwater. The center of the earth principle implies that each landowner has rights to the specific groundwater located beneath their property. For example, for activities like agriculture, industry, and mining. So uh, this center of the earth principle was first applied in the landmark case of Acton and Bladon, and further oil and gas. For oil and gas, the property rights in oil and gas are acquired only by capture, that is, by removing them from the ground and thus converting them into personal property. So, and these can further be seen in the cases like Rolf Burton and Wilson, and the case of Lord Campbell, Bowser, and MacLean, where in this both case, the judgment said that the landowner owns the subsoil beneath their property. And second, surface of land where objects embedded in the soil. This can be seen the amended and lost objects found embedded in the soil on private land belongs to the landowner, which also which also been affirmed in the case of Valley Borough Council and Fletcher 1996. And now we're going to move into the ownership of airspace, lower stratum, where the former common law principle, the maxim, whoever possesses the land possesses it to the sky and the depths. And airspace rights are tied to the land. And this affirmation been uh, been judged in the cases and been affirmed in the cases like Commissioner for Railways and Valuer General, Westin of Learborough and Skyviews and General Limited, and Carlson and Imperial Tobacco Co. But there is one current legal boundaries where, with the advancements of aviation and skyscrapers, the former guidelines became unfeasible because the court started restricting the ownership to the airspace required for the typical use and enjoyment of property. So, the assessment and enhancements of airspace, the law has transitioned total ownership to sensible, practical restrictions reflecting contemporary requirements. And in Malaysia, for a comparison sense, these guidelines are adhered under the National Land Code NRC 1965, where ownership encompasses the airspace reasonably necessary for the enjoyment of land but is subject to public and legal boundaries. Now we're going to see on the fourth dimension in land ownership. So before that, as a recap, a second dimension is where the legal rights and restrictions are restricted to the landowner. The third dimension where the owner owns the sky up to the land below his land. And when it comes to fourth dimension, it is basically the estate, the time where which widen the land ownership of a person. So historically, the fee simple estate could terminate via estate of the owner passed away without heirs, even though the original of estate due to lack of heirs was eradicated. The principle still emerged in current circumstances, such as insolvency. Consequently, the fee simple is not an everlasting estate. The owner cannot confer a lasting rights in land following the principle of one cannot give what one does not possesses, which explained in this Latin maxim. As a sense of reform of land ownership on third dimension, there are several. Firstly, easements provide flexibility. They grant others restricted rights to land for valid reasons, as been affirmed in the case of Re Elmborough Park, form their legal basis. Second, convenient limits ownership for the community advantage, as demonstrated in the case of Tulk and Moxie. Thirdly, in the realm of airspace, instances such as bursting and sky views and laws like the Civil Aviation Act 1949 have reshaped ownership to reflect the reasonable height of use. And fourthly, the Air Navigation Order 2016 additionally regulates drone operations to avoid hazardous or intrusive activities. Finally, Subsurface law, modified via the Infrastructure Act 2015, permits deep drilling over 300 meters without trespass, enabling energy and infrastructure initiatives without needing approval from all surface owners. So, there are certain discussions going on. Will there be fifth dimension and sixth dimension in the future? So what does this mean? The term fifth dimension may relate to the collections of rights connected to land usage, occupation, development, transfer, inheritance, and the sixth dimension might indicate the larger context in which land is situated, social, ecological, financial, and regulatory structures, planning legislation, and environmental safeguards. So, to sum up the presentation, as conclusion, the literal 3D ideal has died. So, Bastian restricted the sky to use while Barcado dismissed underground rights as a hollow victory with little economic worth. This failure demands a shift to the fourth dimension, defining land not as an absolute physical container but as a transition slice of time of or estate. Finally, the legislation changed from a property rule of exclusion to a liability rule of compensation, reducing the landowner to a simple beneficiary of nominal damages. So I would like to put a full stop here for the presentation, and I'm going to end my speech from here. So thank you so much, Doctor, for the opportunity. Thank you, Doctor.